as often as we've done this, and still technical issues. All right, 25 minutes before 11 o'clock, the music and the fact that it's Wednesday. When those two things come together, it means John Fuller is in the studio. Today is the 3rd of July. I tell you the date so you know if it's a live show or not. 2013, July 3rd, 2013, one day before Independence Day. And boy, so much of what we take for granted is because of that day we celebrate tomorrow. John Fuller is here as somebody to answer your questions about the law. He is an attorney with the law firm of Fuller and Fuller, and the show is called Legally Yours, and your questions and comments are invited. The number is the WOCA Climate Control Source Hotline, 622-WOCA. Good morning, John.
Good morning, Larry. You've been working hard there. You had a little technical challenge, and I don't think our space program could have put a man on the moon with more efficiency than you were able to get all that worked out.
But I did it the same way that I put a man on the moon. I had somebody else do it.
Well, it's nice to be with you. And I was just saying before we went on the air, it's a real pleasant surprise to see the sunshine out.
Yeah,
I think we've had 4 days or 5 days of constant rain. I'm not sure I'd do well living in the Northwest where they
I thought the same thing yesterday.
All the time.
I thought the same exact thing.
I told Jen, I said, I think I understand why people get cabin fever. You never see the sunshine.
Yeah.
But anyway, it looks like a beautiful day. Would like to wish all of our listeners, as well as you, and of course all the folks here at WOCA, a very happy 4th of July that's coming up tomorrow. Would like to caution and remind all of our listeners to be very careful and very vigilant if they're on the roads or on the waterways. If they enjoy alcoholic beverages, to be sure and remember that they need to use good common sense and not imbibe to excess so that their normal faculties are impaired. That's one of the legal standards for DUI, and we certainly hope none of our listeners are confronted with that kind of a problem. And using good common sense is not only good for them, but good for the safety of everybody on the road. So we wish them a happy 4th and a very safe 4th of July. It's certainly it's a big day for our country. We tend to sometimes, I think, lose track of these various holidays like Memorial Day, 4th of July, that they're not just about going to the beach, working on your tan, maybe having a barbecue or a cookout. Right. They are rooted in some very, very fundamental, important dates and events about our country, for our country, involving our country. Certainly July 4th was the birth of our nation when the Declaration of Independence was signed. Most people don't realize that it was years after that when the actual Constitution was ultimately ratified.
Yeah, right.
But the first step was the Declaration of Independence, and it was it's very, very critical date for those of us who work in the legal system and for all our citizens, because it created a country that, although it has challenges and it's not perfect. I think everyone would agree with me that we have more privileges, more opportunities, more ability to enjoy life in this country than most any other place that I know of or heard of. So anyway, having said that, we look forward to any of our listeners who may have calls. I know people are probably glued to their TV set watching our criminal justice system at work. There's a lot of live coverage of the Zimmerman trial. I know nothing about the facts of the case, but it is on television, and there are a lot of stations are doing wall-to-wall coverage of it. So it's a good opportunity for people to see the legal system at work.
And you do have a phone call, John. Let's go to the phone. Good morning. You're on the air with John Fuller.
Yes, good morning, Mr. Fuller and Larry.
Sir.
Yes, I'm sharing my radio with the TV set right now. I got both of them on, kind of going back and forth. With a high case like that, an important case like the Casey Anthony case or the Zimmerman case going on now, or even going back to O.J. Simpson, the lawyers that are involved in this, the people that they represent certainly cannot probably afford, because I mean, in certain cases you have like a team of lawyers. How is that worked out with the lawyer and the client that they know they can never pay pay the dues that are demanded upon representing them like that? But do the lawyers kind of like say, gee whiz, I'm gonna kind of eat the pay on that because I'm gonna get a lot of publicity. It's high exposure and it's going to profit me very much in the future. Would that be a true statement?
Well, there's certainly an element of truth in it, but each case is different, and I have no idea how the defense of this case is being financed. It is very apparent that the average American does not have the resources to mount the kind of sophisticated defense that you're seeing being put together in the Zimmerman case.
Right.
And no American is, even the very wealthiest among us, have sufficient wealth that they can match the power and the finances of the government. When the government's prosecuting a citizen for a crime, they have every law enforcement agency, every criminal laboratory with the Florida Department of Law Enforcement. At the federal level, you've got the FBI, the DEA, the Drug Enforcement Association. The government has billions of dollars at its disposal to use fingerprint evidence, DNA evidence, all that sort of stuff. So even the most wealthy individual, when you add it all up, is not particularly well suited financially to be able to do it. I don't know what is going on in this case. I have read or heard that there have been different websites that were started by people who are concerned that the defendant have the resources to have a fair trial and to hire not only just the attorneys. It's important to have a good attorney, but attorneys need the appropriate tools to work with, and those tools are investigators, expert witnesses, and that sort of thing. And so it's a lot more than just paying the attorney fee. But obviously, when you have a trial that lasts 2, 3, 4 weeks, you're going to be looking at legal bills, court costs, expert witness fees that run in the hundreds of thousands of dollars. Now, is that lawyer or some lawyers financially able to bankroll that case, to finance that case under a theory that it would be a lost leader, that somehow that would be good for business? I suspect that the majority of lawyers are not in that position, because not only are they contributing their time without getting compensated, but the entire rest of their practice is being left dormant because they're not there in the office to attend to their other clients' needs and generate an income from that. So it's a very difficult thing. If you are indigent and you have no money, you will get the public defender. If you have some resources, and you're looking to a private attorney, many people, and my experience has been that in the big cases I've been involved with, the people were blessed with a lot of family and friends. Not necessarily that they had unlimited wealth, but if they had 10 or 12 or 15 very good, close family and friends who would loan them the money, advance the funds to them, that's been the experience that I personally have seen happen, where there were cases that involved substantial amounts of time and were very, very, very expensive to prepare. So I don't know how other lawyers do it, and I don't know how it happens in each case, but it's important that a defendant have sufficient funds to be able to have a fair trial. One of the things that truly is not balanced in our criminal justice system, and it's not a matter of the rich getting a a juster form of justice, if you will.
Yeah.
But it is naive to say that if you have the resources to hire talented lawyers with competent investigators and expert witnesses, you have a better chance of an acquittal because you have more tools to challenge the proof of the government of the state of Florida or the government of the United States,
Yeah.
and put them to their rightful task to prove the allegations. And if they can't prove it beyond a reasonable doubt, the citizen is entitled to be acquitted. And that's the way our system works.
Yeah.
So if a person unfortunately doesn't have those kind of resources, he has to do the best he or she can with the resources that they have, and that is a problem.
Yeah.
But I don't know what the individual things are in the Zimmerman case, but I know that it's very expensive.
Yeah.
And very time consuming, and
in a very high profile case where you got a lawyer and you got big lawyer expenses, you got your court expenses like you pointed out and everything else, is it possible for like the defendant to, at the end of everything, just say, "Hey, the heck with it, I'm going to declare bankruptcy"? Can that be done and just walk away?
Yes.
And
Wow.
And he
Yes.
wouldn't have to pay the court or nothing.
Well, I don't know what you say. Pay the court. I don't know what that
Well,
would
the
be.
fees
If a defendant goes to trial,
Yeah.
and he's found not guilty, and he ends up with a $500,000 bill
Yeah.
for attorney's fees and expert witnesses and deposition fees and all the other things that go into mounting a defense,
Yeah.
and he doesn't have it, and that's a debt, unless he is prevented by some code in the bankruptcy law, certainly he can declare bankruptcy.
Yeah, yeah. I wonder if that has ever happened. And again, kind of way it's kind of bad for the lawyers, and there's no way they can really protect themselves from that, right?
If your fee is a debt that is
Yeah.
discharged in bankruptcy, you
Yep.
stand on the same footing as any other creditor that would be washed out in bankruptcy.
Oh,
So
my gosh.
yeah, it is truly a problem.
Problem, yeah.
And it's very difficult, and there are no perfect answers.
Yeah.
Our system tries to do the best it can, that if you can't afford a lawyer, then you have the right to a public defender,
Yeah.
and the court will appoint a public defender to represent you.
Okay, very interesting, and thank you very much.
Thank
Thank
you.
you for
Thank you
calling.
for the call.
I know.
And I think you have another call on the other line. Good morning. Oh, I guess not. There was somebody trying to get through.
Sorry if that was a too long-winded answer, but it's there's no good answer to that because every case is different. There are laws that prevent a person who's charged with a crime from profiting from it by writing a book. So that's not a source of revenue if a person is convicted.
That's across the board? Everybody has it?
I think so.
Oh, wow. Good morning. You're on the air with John Fuller.
Good morning, Mr. Fuller. Enjoyed your last explanation.
Good morning, sir. How are you?
Oh, pretty good. That that your last summary in regards to the powers that the government have, it's been something that I think a lot of people, especially poor people, really know. I mean, they understand that well, because as you said, when you go to trial, I mean, you got the state attorney has all the resources, and especially if you're indigent, which is in most cases, I mean, you do depend on the public defender, so it is what it is. You get what you get, what you pay for. My other question is this: on this new law in regards to having to take, I guess, an oath in regards to these automobile accidents and stuff like that. What is your opinion in terms of how that's going to impact drivers? I'll hang up and listen to your.
What was the? I'm
radio.
sorry. What was the question about? What law? How's it impact? I didn't hear part of that. I apologize.
This new law recently that Florida State Supreme Court had a hand in making a ruling on, I guess yesterday or the day before, in regards to when you have an automobile accident.
Right.
That if you go to court and stuff and those types of things like that, and if you have an injury and you file suit, you got to automatically be put on the oath where you didn't have to do that in the past. What impact do you think that that's going to have on the new drivers? And do you think that it will require more attorneys be available to people that are involved in automobile accidents in the future? I'll hang up and listen to your answer off the air, but I also hope you guys have a happy 4th of July.
Thank you, and you too, sir. I have not read the opinion that you refer to, so I'm not sure exactly what the law says about that.
I know he's referring to something we were talking about this morning, and I can probably paraphrase it for you rather than finding the paperwork.
Yeah, go right ahead, because I am not.
The gist of it sounded like the Florida Supreme Court. Oh, I know. It's this one right here with the guy. I'm looking right at it. I just was looking at the Geico and forgot. I'll just read it to you rather than trying to paraphrase it. In a blow to the insurance industry, a divided Florida Supreme Court on Thursday, which would have been last Thursday, ruled that Geico could not require a woman to give a statement under oath as a condition of receiving injury benefits after an auto accident. The 5-2 ruling found that Florida's personal injury protection laws in the past did not allow the insurer to place such a requirement on the plaintiff, identified as Merle Nunez, and other people like her, calling it unreasonable and unnecessary. The majority pointed out that a goal of the PIP or no-fault system is to resolve injury claims quickly. And then the other part that he was referring to was this part. Florida lawmakers in 2012 revamped the state's PIP laws, as you talked about greatly, and specifically included that policies could require examinations under oath, but the Supreme Court majority said that change does not apply to cases that arose before the new laws took effect January 1st. And what we got out of that, me and the listeners and I, is that if you were in an accident before January 1st, you were not under any obligation to give a statement under oath. Now you are.
Well, that's an interesting point, and you've summarized it, and that is exactly the status of the law. The whole premise of personal injury protection is a no-fault premise, that if you're in an accident and you're injured, you're entitled to the no-fault benefits that you pay for when you pay your premium, and you don't have to prove any entitlement to that. You just have to show the medical records, the lost wages, and they have to pay it. A number of companies engrafted a condition of that before they would, they had a chance to basically make their own insured swear under oath, and they would cross-examine them about the events of the accident or what happened, and they did it under the theory that because it was a contractual relationship, you had an implied condition to cooperate with your insured. The Supreme Court has held that's improper. What has happened is that the case that was being litigated, that the Supreme Court ruled 5-2 on last Thursday, that said what we basically always understood the law to say, is that they didn't have a right to do that, applied to the law that existed at the time that case arose, which, as we know it now, was the, quote, old PIP statute, which was vastly gutted and changed in January 1 with the new PIP statute, which is somewhat of an aberration to the no-fault concept, because it does set up an adversarial relationship, and it did so under the guise that people were filing fraudulent PIP claims, and so they called it an anti-fraud type thing. We've talked about before. The governor pushed it through by calling in political chips that he had on the last day of the session last year, not 2013, but 2012, and I think ultimately that law will be declared unconstitutional. There are cases that are pending at the trial court level that will ultimately work their way through the system up to the Supreme Court. It takes a while for them to get there because you have to go one step at a time, and you have to try it and raise the issue and have a justiciable issue at the trial level that the judge rules on, and then that gets appealed, and it ultimately gets to the Supreme Supreme Court.
Wow.
This law just went into effect, so you have to wait until you have an accident that occurred after January 1 of 2013 in order to do it, and the system hasn't had enough time to respond to that. What the court said in the 5-2 opinion is that, however, the new law, the legislature probably foresaw this opinion coming, because I think anybody who understood the concept of PIP being no fault would say, wait a minute, it shouldn't have these strings attached. When you paid your premium, you basically bought this.
Yeah, right.
They took your money, now you're hurt, and now they want to make you jump through all these hoops just to get what you already paid for. In anticipating that maybe that would happen, the insurance lobby, which is a hugely financed, very powerful, very influential lobby with a bunch of conservative legislators and the governor, probably saw that the Supreme Court was going to hold that practice was not consistent with the law and was in fact improper, which they did. So what did they do? Exercising their legislative privilege, they passed a law that made that a provision that you now have to give a sworn statement before you're entitled to get the no-fault benefits that you should be entitled to just by virtue of being hurt. So what the court will do with that, this particular decision in the Geico case last Thursday said this opinion applies to the law as it existed, and it does not apply to the 2012 law, because that law, this issue has not been presented to us in the context of that law, and we're not going to anticipatorily rule on an issue that's not before us. But sooner or later it will be before them, and I think the Geico case is going to be a pretty good precedent that if it's the public policy that the court says people who buy PIP ought to be able to get these benefits without having these types of conditions engrafted upon it, either by the company or the legislature, unless the legislature has made a sufficient showing of a public need, then that case is probably going to be pretty well cited when it's argued. I think it's also interesting that it was a 5-2 opinion, so it wasn't like one of these things where the court was badly divided. They were apparently two justices who did not side with the majority. But I think you're going to have much more litigation arising out of that new PIP statute, because I think it basically deprives people of their constitutional right to access to the court, and I think the law is unconstitutional. I've said that before on the air, and I certainly am not alone in that opinion. And it remains to be seen how the court deals with it.
You do have another call. I just want to slip in that this morning the conclusion we came to was that until that gets changed again back to where maybe it should be, we need a lawyer when we give that oath. Because obviously, if we're in an accident right now, they're going to require that oath.
They do, and I've had it happen, and I make them take my client's oath. Take my client's statement in my office with me present.
That's what I think should happen,
and whether they want to do it over the telephone or in person, we cooperate with them. Otherwise, they'll deny your benefits under the policy. But if they ask questions that I think are inappropriate outside the scope of their even arguable justification for taking it, then I have a right to stop it and say, no, we're not going to address that issue. That's irrelevant to the issue of his injury, the amount of his medical bills, and the amount of his wages. And
that's why we call you. That's why you're an attorney.
That's the way we're handling them now.
And we had enough time to squeeze in a quick one. Good morning. Thank you for waiting. You're on the air with John Fuller. Are you there?
I'm sorry, we've had a number of very complex questions that have had a lot of a lot of issues to discuss, and I apologize to our listeners who may call and get tired of holding. I know that can be frustrating, and I get irritated when that happens to me, and we're not doing it on purpose, but I don't want to, in answering a question, I don't want to leave something that is only partially answered or make a statement that is incomplete that might mislead any of our listeners. And like I always say, if you have a problem, if you're in an accident, do call and have a consultation. If you're in an accident and you want to talk to us, call us at the office. Our local number is 352-547-4292. We'll be happy to schedule you an appointment, talk with you about the accident, your injuries, your PIP claim, whether or not you may have a lawsuit against the at-fault driver who hit you. But again, I want to remind everybody that under this new law, if you don't go seek medical attention, it has to be with a medical doctor, a nurse practitioner, a physician's assistant, or a doctor of osteopathic medicine. If you don't see one of those 4 medical providers within 14 days of your accident, you will lose 3/4 of the insurance no-fault benefits that you bought and paid for, where it says you have $10,000 in coverage. If you don't go see a doctor within 14 days of the date of the injury, your benefits are automatically reduced to $2,500. And no longer can you go to a chiropractor alone. It's okay to get chiropractic treatment, but you have to see a medical doctor, a doctor of osteopathy, a nurse practitioner, or a physician's assistant within that 14-day period of time. Otherwise, you lose those benefits.
In other words, just like when I got somebody to help me with the technical issue in the beginning, if you've got a legal issue, you better get somebody who knows the law.
Well, it certainly makes a catch-22 on someone who may not really wants to try to work things out. There are a lot of people out there who have high pain tolerances. They were raised not to be complainers or malingerers. They're not looking for a free lunch. They're trying to tough it out. And some injuries you have in automobile accidents are slowly emergent. You can have an injury and some of the symptoms are slow in developing. And I just think it's a very bad law passed for the sole purpose of the financial benefit of one financial segment of society. And I truly believe that the courts, when they look at that, will hold that law, or at least substantial portions of that law, unconstitutional.
You would think so. You would hope so. Always a great show, John. It's a very fascinating, and you illustrate for us every single week why it's important to have an attorney who knows how to do what you do. Thank you for doing the show.
Thank you, Larry. Always a pleasure, and have a nice 4th of July.
Yeah, you too. We'll take a little break. We'll be right back.
Ocala's information station, 1370 WOCA. Ocala.
ABC News Now. I'm Karen Chase. The commute shouldn't be as crowded as last year for your 4th of July getaway. Over 34 million are expected to travel 50 miles or more to their holiday destinations. Unrest in Egypt has pushed oil prices over the $100 a barrel mark for the first time in over a year. But gas prices